Moving towards our second session, we have with us today an expert resource, Advocate Devanshu Gupta Sir. Welcome, sir. Devanshu Gupta Sir currently is an associate at Link Legal and a part of corporate and competition law team. With his strong interest in global competition and merger control laws, he has advised and represented various clients in antitrust laws and merger control enforcement issues and challenges. He graduated with BA LLB Honours degree from Dr. Ram Manohar Lohia, National Law University, Lucknow, and did his post-graduation, that is LLM, from Jamia Millia Islamia in Criminal Justice and Law Enforcement Administration. He is a PhD research scholar at the Center for Competition Law and Policy, GLA University, Uttar Pradesh. Advocate Devanshu Gupta has worked with several reputed law firms like KK Sharma, Khaitan & Co., Competition Advisory Services, and now Link Legal. Through his experiences, he has gained expertise in competition law and its related domains. He has also worked in the firm of founding chair, Competition Commission of India, and has acted for various clients on competition enforcement issues, cartelization, dominance abuse, merger clearance, policy, and regulatory strategies. In 2018, he assisted as a member of non-government agencies and contributed to the expert research report on cartel enforcement and competition, the International Competition Network in India. He is also empaneled in Delhi State Service Legal Authority as a legal service advocate and appears before the courts and tribunals in Delhi NCR. Apart from this, he is an author and has shared his views in several articles as a part of Link Legal. The prominent amongst them are maritime transport service providers penalized for centralization in India and overriding effects of Competition Act. These articles prove to be indeed beneficial for all the persons in the legal field. Advocate Devanshu Gupta has also been the judge for preliminary rounds at the first Nalsar CCI, that is Competition Commission of India Antitrust Moot Court Competition 2022. We are extremely grateful to have such a distinctive personality with us today.
Thank you for the warm introduction and kind invitation. It is such a pleasure to be here with you all. And as already introduced, I would be talking on competition laws in India and how they have developed as a major law in India. So I would be covering the corporate legal outlook and which is majorly dealt by NCLT, NCLAT, SEBI, IBC, CCI and the Supreme Court, which is the final authority in India. Majorly the corporate legal outlook is based on matters on corporate law with NCLT and NCLAT. SEBI has been a regulator of securities, and CCI was established as a market regulator. It is not a sector regulator but a market regulator. I would come to these things later, and I wanted to give a brief of the competition law because it is thought that it is a complex law, but I want to give a brief of that so you all can have the base of it, and you can always apply for internships in competition law, which is always a growing field. It has been a major law globally, but in India it was introduced in 2002 only. So, and which is still growing. Major amendments are pending in Parliament. So I would be dealing with the antitrust laws in India, why it matters for businesses, the major Section 3 anti-competitive agreement, horizontal agreement, vertical agreement. I have covered a case law on anti-competitive agreements. Then we will discuss about Section 4, which is abuse of dominance, and Section 5, which is merger control, basically M&A, and what are the risk of non-compliances for businesses, and that you as a student can also understand and later portray your understanding in competition laws. Then we would be having some question and answers in the end, and where I can tell you something about my experiences, and we can move forward with question and answers. So as I said, that the corporate majorly a corporate team in a law firm majorly deals with company law cases which are dealt in NCLT. The appellate part are dealt in NCLAT, which is National Company Law Appellate Tribunal. And there are sector regulators. The IBC is for insolvency cases, for stressed assets. Then the a lot of money is coming in, then there should be some regulator in the market who can check the balance, check a balance in the market, keep a check and balance in the market. So with that approach, many new acts were debated in Parliament, and in after 1991, after liberalization, many regulators were set up. So at that time, SEBI was set up, later CCI was set up, and these regulators are still regulating the sectors and the market. So as you can see that companies with the adoption of Companies Act 2013, NCLT and NCLAT were established for seeing company law cases. The company law board, which was earlier there, was abolished and NCLT was established. There are 11 benches of NCLT in India, and each has different jurisdiction. Relevant for us today is NCLT Mumbai, which oversees the jurisdiction of Chhattisgarh, Goa, and Maharashtra. So through this, I want to just convey that NCLT practice is also one of the very fine, decent practice, and which is going to be something big for you. So you should, and this is something which will not come easily. It will, you have to gain experiences, you have to understand the law, which will take time. So there, then I have covered a slide on SEBI, which is the sectoral, which is the securities market regulator, and it is responsible for registration, regulation, and the after market effects in the securities market. It is basically for the protection of investors, for subscribers. So at least they are in the market, in the securities market, they feel protected and they keep spending. And basically this was done to give a rise to ease of doing business in India. The major acts, you can see that it is on the SEBI Act, the Securities Contract Regulation Act, SCRA, Depositories Act, and many more rules and regulations. So now I would start dealing with competition laws, which has been my major interest, and I have worked in this only majorly. So Competition Act was passed in 2002, and the commission was established. A competition commission was established in India. With the establishment of the Competition Commission of India, it was made responsible for taking care of the market distortions. For example, if we consider this audience as a market, and if I allow if I take some test and allow some of the students to cheat, or some good students to use the position gained by them, then it would be unfair for other players. It would be unfair for other students. So for that reason, regulator was set up, competition commission was set up. to take care of the market distortions, to take care that no big player is misusing its position in the market, to take care that no anti-competitive agreements are made. So as you can see, the preamble of the act tells about that it is an act to prevent practices having adverse effect on competition, promote and sustain competition in market, protects the interest of consumer, ensure freedom of trade carried on by other participant in market in India. So as you can see, these are so open-ended words that each and everything can fall in it. And basically, the fundamental laws of competition are generally covered as it prohibits anti-competitive activities, anti-competitive agreements. It prohibits abuse of dominant position in the market, and it regulates merger. If a merger is beyond a certain monetary threshold, then it has to go. It has to be cleared by the Competition Commission. Majorly, the idea is to give you some understanding of this competition law, so you all can, in this 20 minutes, in the 30 minutes, you all can take away this subject as having some understanding in it. So, basically the act covers section 3, which is the anti-competitive agreements. It defines two types of agreement, that are horizontal agreement and vertical agreement. Horizontal agreement meaning that agreement is with players in the same line of business, meaning thereby that a car manufacturer or a car manufacturer, two car manufacturers, or two players from the same market operating at the same level. So agreement between them has been, there are four types of agreements, horizontal agreements that have been prohibited. I would deal with it in the next slide. And the vertical agreements, the next genre is that vertical agreements are agreements that would be between enterprises operating at different level of in different line of business. So meaning thereby a manufacturer or a distributor or a reseller would be in a vertical relationship, and agreements type of five type of agreements formed between them would be anti-competitive if they fall within the legal given the then there are also certain exemptions in form of joint ventures. When there are agreements, joint venture is also an agreement. So it has been exempted, but it has to be with a clean team. That it do not has to be that many players coming together and forming anti-competitive agreements and dominating the market. And there are reasonable protection for IPR, and there are reasonable protection for export from India. These three things are not covered under the domain of anti-competitive activities, anti-competitive agreements. So, like I said, that horizontal agreements that are between the same players between the same line of business. So there are five type of agreements that are prohibited. That any agreement between players of same line of business which determines purchase and sale price. So as you can see that it is so open-ended that any two players which are talking about or agreeing to determine a price is illegal. So the act has inserted so open-ended word that each and everything can be put in it, because businesses are just going on with agreements, majorly on agreements, which certain types of it have been prohibited under the act. Then agreements for limiting, controlling markets or technical development in the market, these agreements are prohibited. Bid rigging or collusive bidding, that in a tender process or in some public procurement, two players operating at the same level are colluding and rigging the bids to submit the same amount or less amount to not going through the fair competitive process. So that has been prohibited. Lastly, cartels have been prohibited. As you know, that cartel is agreements between different horizontal players who would be agreeing to not to do or not to do certain activities in the market. So that has been prohibited, and these five type of agreements are, these shall be presumed. So the scope of rebuttal is very limited, and it is on the parties to, specifically prove that no such agreement was formed between the parties through the evidences, through, the documents and emails they have to show. Next type of agreements are vertical agreements. These are between, players between different line operating at different line of business. So any vertical agreement in form of tie-in agreement, exclusive supply agreement, exclusive distribution agreement, refusal to deal, or resale price maintenance. So these five type of agreements are not per se illegal, but they are judged from the rule of reason. So meaning thereby that it is on the Director General, which is the investigating wing of the Competition Commission of India. It is the responsibility of the DG to put strong evidences in its report that suggest that there were vertical agreement and it created an appreciable adverse effect in the competition in India to penalize a enterprise. Recently, Maruti Suzuki was penalized for about 200 crores for resale price maintenance, for making, contracts, vertical contracts with its distributors, and fixing a price for resale price. So that was prohibited, and it costed Maruti a lot. So the Supreme Court, in the case of CCI versus Coordinate Committee of Artists and Technicians of West Bengal, it is a very nice case. I would say everyone to go through this case. Uh, uh, in this, it was decided by the Supreme Court that it is first necessary to find an agreement relate to economic activity to find a contravention of Section 3, which is anti-competitive agreements. And the economic activity includes any activity that involves economic trade, irrespective of whether it makes a profit or not. So, the act always given open-ended power to the commission, and with the interference of the Supreme Court, the power, has been extended, further extended. Further, the Supreme Court said that any entity, when it engages in an economic activity, constitutes an enterprise within the meaning of Section 3, regardless of its form. So it could be, unregistered company, it could be uh, any enterprise which can be penalized. And there are certain factors given in the act, and that should be considered by the commission, and these factors are inserted for the convenience of the parties and the commission, and also during the investigation process by the DG. Then we would move to Section 4, which is abuse of dominant position. A dominant position in the market is, it's self-evident that you would be able to understand that it is a position, to operate in a market without having any, without without having a good influence in the market, and that may have an effect of distorting competition. So there are there are five kind of activities that are prohibited under the act, and when it is found that any dominant enterprise is imposing unfair or discretionary condition or price in purchase of sale, which includes predatory pricing, which is selling below the average variable cost. And second one is limiting or restricting the production of goods or services or markets for prejudice of consumers. Third is denial of market access. Fourth is concluding contracts which by their nature or according to commercial usage have no connection with the subject of contract. And lastly, it's using its dominant position in one market to enter any other market. So these are the 5 kind of activities that are prohibited under the Act, Competition Act, and any dominant enterprise doing these activities would be prohibited. Then majorly, which is in law firms in the competition practice, the major work is in merger control. Like I can say that 70 to 80% is of merger control. The 30% work is of enforcement. So like section 3 and 4, which I had discussed with you, that are known as enforcement cases, and this is a separate wing of the Competition Commission, which regulates the mergers in India, and it controls the mergers. Since there are a lot of mergers going on, and the Commission, the Act has established a monetary threshold, and beyond which only any two enterprises going on for a merger, if they cross that certain monetary threshold in India and abroad, then only they are supposed to take the approval from the Competition Commission. Also, recently the Commission has came up with a green channel approval. Green channel approval is deemed approval as parties file with the CCI. It is considered as the merger notice is considered as approved. So these all activities, these all laws have been established to give boost to the ease of doing business in India. So now CCI has been approving 1 out of 5 merger and acquisition under its green channel route. So this is also very interesting subject. It's a separate subject, I would say, in competition law, which if anyone wanting to practice in competition law should be very much aware about these technicalities in merger control. Then CCI has power to penalize if any companies which had the responsibility of filing a notice with CCI and take approval from CCI, but it has not filed the notice and it has jumped the gun, which is known as gun jumping. So CCI has the power to penalize that enterprise to the tune of 1% of its turnover, and whichever is higher. And it is on the total turnover. It is not on the relevant turnover, which is also something we can discuss. So, what are the risk of non-compliances in India? So, first is the imposition of heavy penalties, fine up to 10% of turnover for the last 3 financial years. And in cartels, fines can go up to 3 times the profit made. So generally CCI penalties are very high. CCI penalties are never less. It's never limited. I have not very limited number of cases I've seen in the penalty was imposed in lakhs. It is generally in crores, the penalty. So that is why the corporates are afraid of this law, because they are not firstly aware of this law, and secondly they would have to have this understanding of this law, because the agreements are formed by non-lawyers generally. The non-lawyers or salespeople or executive members go for meetings and they form contract or they settle the things. So it may be a situation that they are not aware that such activity has been prohibited, and later they can come under the review of Competition Commission and can be penalized. So it also causes reputational damage, because CCI cases are very well covered in newspaper. So it causes reputational damage to any enterprise. Individual penalties are also, the provision for individual penalties are also there in the Act. So any director management or manager who is responsible for making contract or for doing that thing, which the enterprise has been penalized. So the same amount of penalty would be also be given to the concerned individual person. Then the agreement would be, of course, would be after giving a penalty or after CCI coming to the conclusion that the enterprise has uh, misusing its position or not following the Competition Act, uh, then such agreement would be declared void and unenforceable. Then the commission is also had the power to suggest changes to any merger control. Suppose two enterprises, big enterprises, are going for merger, and CCI found that this merger can cause some distortion in the market. So CCI can also suggest some structural and behavioral remedies, meaning thereby that structural remedies are in form of some divestments, that two big companies, CCI would say that remove some of the units or some of the patents that you have. Then behavioral remedies are one that regulates the behavior of the enterprise after the merger. It can be like giving access on FRAN terms, fair, reasonable, and non-discretionary terms. It can be in form of giving access to some supplies and not restricting any player to enter the market. That could be some behavioral remedies suggested by the CCI. Then there is also provision for class action for damages. Class actions are, when activity of an enterprise has affected a lot of people. So uh, all can collectively go to court and claim damages from the enterprise. So which is quite new concept in India, and only I think one or two uh, class action suits have been filed in NCLAT. And then there are legal costs involved, because since the practitioners in this area are limited and majorly dealt with tier 1 law firms which have got separate teams, uh, so they charge a lot from clients, and for that reason I would say that it also gives an opportunity to you people to develop an understanding in this law and do internships, as many internships as you can do in competition law, and can, if you are interested, can develop a career in competition law also, which is itself a separate law. Then what are the career opportunities in competition law? It can be through internships. CCI has also started giving internships, so I think you should apply, and it is in hybrid mode also, which is useful for women candidates. And law firms have separate competition law teams. There is a different corporate team, there is a different team for SEBI, there is a different team for competition law issues. So they have segregated and provide expertise to give expertise to their clients. They have segregated their teams, and they are hiring in a limited number, because since this is something which needs understanding, which requires a bit of a good understanding actually of the law, because the words are so open ended that you can a case can, due to some research, a case can fall short of it. And so how to prepare for upcoming job opportunities in corporate law? uh, uh, since laws are all or majorly introduced through public consultations, so I would suggest the college to participate in public consultations. And public consultations are for stakeholders, and for anyone can give their comments to any new legislation or policy which is upcoming. So that would also give a new understanding to the students that something new is coming, and if they are interested, they can pursue this as their career. So, how to earn internships in firm? I would say that LinkedIn has, developed as a big platform, and I would say that you should reach out to people on LinkedIn, share your ideas, message them to, get guidance, and I am sure if you will, message 10 people, I think one or two, or if you're lucky, 5, 8, 10 will reply back to you and will give you some, understanding. Then the skills which are required. So according to me, I think that, understanding of established concept is very important. That you should have, it is very important to know what was said in Keshwan Bharti. So even from a competition law background, I have always been very diligent on understanding the criminal law, the civil law, the administrative law. So the constitution. So these are the grand norms. So you should be very much, involved in this, because uh, they are there always. They are the grand norms. And even if you are practicing as a competition lawyer, or a, IBC, in an insolvency professional, or you are doing SEBI matters, but the understanding of constitution, the understanding of civil and criminal law will give you a in-depth understanding of the sectoral laws for which you are practicing. Because at the end of the day, it is the Supreme Court which will take care of any issue that may arise in the market, or in the between the enterprises. Then I would say that written and verbal communication is very important, and I keep working on that also still, because it is something which will gradually come. It will not come in one day. It has a transition time. It will come after years and years of practice. Then I think that submissiveness and the right attitude is very important. That you need to be submissive to, if someone is telling you something, you need to just give him something, give your time to hear him out, and be submissive to understand that what has been said or what is intended to be said. Uh, and the right attitude is very important. That you always need to be have a right attitude. And then smartness in actions. You need to be smart, and that would come in time. And uh, I think that as good you involve yourself in these activities, and as I can see that the your law school is always with you, and it is always keep on organizing such events to get some insights or experience sharing from the industry to you people directly, for which you should be very thankful to the faculty, and must be very supportive to it. And with this, I would like to take some questions, or any doubts if you may have. I would be dealing with that. And thank you so much for hearing me. Thank you.
Thank you, sir, for such an insightful session. Do we have any questions from the participants? Yes.
Hello, sir. Myself Atharo Deshmukh. So, as you have said, this act is a competition law. Then why patents and trademarks are excluded from this? Why patents and trademarks are excluded from this?
Because intellectual properties some are someone's work. So that is why patents and trademarks, these are exempted from the preview of anti-competitive activities. Meaning thereby that, for if you are having a patent, then you can put some, whenever you are sharing that patent with anyone, you can put, reasonable restrictions to that, and that would not amount to being anti-competitive.
But sir, still patents and trademarks plays the important role in competition law. Means
They are, they are exempted actually.
means they are means they have more power.
Actually, intellectual property is your own work. It is your own work. So in the IP Act, in the IP Act, that is why reasonable protection has been given to each and every creator. Suppose you have created something and you do not want to share that, or you do not want to share that in less money, then you should have a right to, protect your invention. So that is why the exemption has been given, so that, when you have created something as an intellectual property, so you would have that right to protect that, and for that you can, when while sharing it to anyone, you can put some anti-competitive agreements. So that is why that has been exempted.
Thank you
Thank
so
you.
much, participant. Moving towards conclusion, the information shared by you, sir, in an explicit manner about the corporate domains and organizations which work in these domains is indeed an insightful one. I would like to thank all the participants here for the patient hearing, and thank you, sir, for guiding us with the most trending and important topic like the corporate legal outlook. Uh, I would like to request the participant to fill up the feedback form that is in the registration kit and submit it at the registration desk at the end of the day. Thank you so much once again. Now I request Aishwarya to proceed further.
Sir, I'm so sorry to be late with my question. The question goes like myself, Sahil Srivastav. The question is: we all know the case of Ruchi Soya. So the first bidder, the primary bidder was Adani Wilmar. Now, if we look at from a market perspective or a sector perspective, Adani is a leading company in oil, and Ruchi Soya was also a very big oil company. Now, that coming under the purview of IBC, a buyout order can be made by anyone given the conditions are complied with. Does competition law in its in the letter and spirit speak about whether an insolvent company being bought out by a solvent company having the same line of business, are there any conditions in company competition law as well?
Well, competition law regulates a different prospect actually. It regulates the market. So IBC cases, there for this is for stressed assets, but it is not like that. You can, as I told you, that there are three verticals. That is anti-competitive agreements, abuse of dominance, and merger control. I think that your question would fall in merger control because that is a merger and acquisition, because a stressed asset was acquired. But that would not come under the preview of CCI because CCI has prescribed a monetary threshold. So I would say that it would be there that that threshold would not have been crossed. So the threshold is like 2,500 crores. So it is a big threshold in India and abroad. So you need to have minimum 2,500 crores in India, and it ranges to 1,800 crores in India and abroad. The value, the turnover in terms of turnover and assets, if the value crosses these thresholds, then only the enterprise is responsible for taking the approval of the commission. Otherwise, there are also certain exemptions provided in the act. I would tell that that is de minimis exemption. It is known as small target exemption. So basically, it exempts any company. Suppose you are a big player, you are having 1,000 crore, and you want to buy a company which is having worth of less than 350 crore of asset or less than 1,000 crore of turnover in India, then that has been exempted from the preview of the act, because the major intention of the act is to regulate big mergers. So that can later distort the competition. That can big that can later become a bigger and the only player in the market. So for that situation, the certain mergers beyond a certain threshold have been restricted. So
Thank you, sir.
I think I have
Yeah.
answered your question.
Yes, yes, you did. Thank you so much.
Thank you. Please, any other question? I would be very happy to share my experience or knowledge in competition law.
Hello, sir. Myself, Sai Kulkarni. I would like to know what is your day-to-day task, or what should we expect as lawyers coming into the competition field?
It is I would say that according to my experience, this practice has been I have practiced criminal, civil, and I think this is the most royal practice, I would say, in law firms and in corporate culture, because they have a dedicated team, and each team is responsible for just competition and merger cases. So in a regular day, we sometimes have to visit the commission. We sometimes have to visit the director general office. We have to represent clients sometimes in CCI and DG office, in NCLAT also, where the appeals are going. And also the work involves a lot of research, because as I told you, that the legislation puts words are so open-ended that each and every agreement can fall in it. So due to your good research and your good understanding, you can save your client from falling into that trap. So research is very important. Research, drafting, writing. It is generally it is like that, and also sometimes appearing in CCI, DG office, and NCLAT, and even the Supreme Court, if the wherever the matter is. Thank you.